It's perfectly fine to say, Martha, can you, I'm having trouble with the slides, can you take them back over? And she can do it. But if things go over, that's fine.
Thank you. Ready.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. I'm Amy Quackenboss, the Deputy Executive Director of the American Bankruptcy Institute. For those of you who are not familiar with us, the ABI is the largest multidisciplinary nonpartisan organization dedicated to research and education on matters related to insolvency. As an ABI member, you have access to a wealth of free online research and networking tools, as well as quality CLE programming. And today, I'm pleased to welcome you to the latest in our webinar series, ABI-Live. Today's webinar is being hosted by ABI's Bankruptcy Litigation Committee and promises to provide you with everything you need to know about bankruptcy appeals. Before we get started, there are a couple of housekeeping matters to discuss. First, if you purchase CLE for this program, please make sure that you jot down the CLE codes that will appear throughout the program in the chat function box of the GoToWebinar page. You will receive a follow-up email from us with directions on how to get your CLE credit. Also, if you have questions that you'd like to ask during the program, you can type your questions at any time in the questions box that appears in the webinar control panel. These questions will go straight to our panel and will be addressed as time permits at the end of the program. I now have the privilege of introducing our panel. The Honorable Susan Graber, who was appointed to the United States Court of Appeals for the Ninth Circuit in 1998, previously served on the Oregon Court of Appeals and the Oregon Supreme Court. Judge Graber is a member of the Rules of Practice and Procedure Committee of the Judicial Conference of the United States, and in 2000, Judge Graber chaired the American Bar Association's Committee on Appellate Practice. She was named Oregon's 1998 Legal Citizen of the Year, and in 2001 received Yale's Tercentenary Four-Country Award in Oregon. Our next panelist is the Honorable Joan Feeney. Judge Feeney is a United States bankruptcy judge for the District of Massachusetts. She is the Chief Judge of the First Circuit Bankruptcy Appellate Panel, and she is a fellow and member of the Board of Regents of the American College of Bankruptcy. Judge Feeney was also the president of the National Conference of Bankruptcy Judges in 2011 and 2012. In 2005, Judge Feeney received the Boston Bar Association's Haskell-Cohn Award for Distinguished Judicial Service. Our final panelist is Danielle Spinelli, who serves as the Vice Chair of the Appellate and Supreme Court Litigation Group at WilmerHale in Washington, D.C. Her practice includes advocacy in the Supreme Court, in courts of appeals, and in trial-level matters involving complex legal questions, with a particular emphasis on matters involving bankruptcy, administrative law, constitutional law, criminal law and procedure, and federal Indian law. Ms. Spinelli has argued before the Supreme Court 4 times, most recently in the bankruptcy cases of Bank of America v. Calkett and Clark v. Ramaker. Thanks to each of our panelists in advance for sharing your thoughts and experiences relating to the bankruptcy appeals process with our audience today. Judge Feeney, I'll hand the program over to you to begin.
Thank you, Amy. I'd also like to express the appreciation of all the panelists to Jeremy Fisher, who organized this webinar and who did the written materials, which I believe the attendees have access to, and also Martha Cannon of ABI for her assistance in connection with this webinar. We're going to start the PowerPoint presentation, which I hope you all have access to as well. And I will outline briefly what we are going to discuss today, the important aspects of bankruptcy appeals. We'll start with the statutory predicates for appellate review of bankruptcy court orders, the choices of forum for the intermediate appellate court, the available options and strategies for deciding which court a litigant should choose, as well as direct appeals to the circuit. We'll then proceed to discuss what orders of a bankruptcy court can be appealed, noting the distinction between final orders and interlocutory orders. We'll then move to the limitations on appellate jurisdiction, including reasons for dismissing appeals before adjudication on the merits. We'll provide practical insights and advice on writing briefs and conducting oral arguments by Judge Graber. And finally, Danielle will focus on practice before the Supreme Court of the United States in bankruptcy appeals. Bankruptcy appeals are governed by their own statutes and rules. Danielle, could you please provide an overview of the applicable statutes and procedural rules?
Yeah, I'm happy to, Judge Feeney. So the slide that's up right now is a pretty good summary. You always need to start with 28 U.S.C. 158, which sets out the appellate jurisdiction of the district court, the bankruptcy appellate panel, and the Court of Appeals, to make sure that you fall within that jurisdiction and that you're using the correct procedure. And then there's the 8,000 series of bankruptcy rules, which govern appeals from bankruptcy courts to district courts or BAPs. BAPs and district courts can also have their own local rules, which are important to look at. District courts don't always have these for bankruptcy appeals, but some do. For instance, the District of Massachusetts has a pretty detailed rule about handling bankruptcy appeals. And then when you're going from the district court or the BAP to appeals, you, of course, want to look at the federal rules of appellate procedure, which differ in some respects from the bankruptcy rules.
The attendees should note that in 2014, the federal rules of bankruptcy procedure, including those in Part 8 governing bankruptcy appeals, were substantially amended. Now
That's a good.
Let's move to choices of forums. In 5 of the 12 circuits, the 1st, 6th, 8th, 9th, and 10th, parties can take their appeal to either a bankruptcy appellate panel, which is the default appellate intermediate court, or the parties can make an election to proceed with their appeal in the United States District Court as the intermediate appellate court. In other circuits besides those I just mentioned, the only intermediate appellate court is the district court. And from those 2 courts, the BAP or the district court, an appeal goes to the Circuit Court of Appeals, and then if cert is granted, to the Supreme Court. Danielle, could you go over how an election for the intermediate appellate court is made in the 5 circuits where there are BAPs, and then address the factors that counsel should consider in deciding which court to appeal to when there is the BAP option?
Sure. So, I mean, just an observation, I think it's curious that there are BAPs in only 5 circuits, because if you look at Section 158, the default is that there is a BAP and there have to be special findings made in order for there not to be a BAP. And every bankruptcy judge and district judge I've ever spoken to loves the idea of the BAP. In order to make the election, the appeals in those circuits will automatically go to the BAP unless one party elects otherwise. And if you, the appellant, want to elect otherwise, you should put that in your notice of appeal. As for where to go, your choice is really driven, I think, by tactical considerations. Do you want a group of bankruptcy specialists ruling on your appeal? You might want that, for instance, if you have a complicated issue of bankruptcy law and you're worried that, you know, it might be difficult for a generalist judge and that, you know, a BAP will dig deeper into it. Or, you know, you might want someone to take a fresh approach and not look at the law in the way that a bankruptcy judge typically would. And in that case, you know, you would want to go to the district court. You might also think about which court is likely to be the most deferential to the bankruptcy court. I actually think the bankruptcy appellate panel frequently is going to be less deferential, at least on issues of bankruptcy law, because it's within their expertise.
All right. I just have one chime-in point. In my experience, observing both district court opinions in appeals and BAP decisions in appeals, generally the BAPs are quicker in making a decision. So if a party wants a quicker decision, the BAP might be the more appropriate forum. We actually looked at this a little in the context of the Ninth Circuit, and although we didn't find a significant timing difference, we found that BAP decisions are affirmed by the Ninth Circuit much more often, and so you can make of that whatever you wish to, but it was an interesting fact. Well, there are, in addition to proceeding in the intermediate appellate court, there is now a procedure in 28 U.S.C. 158 for bypassing the intermediate appellate court and going directly to the Court of Appeals. And this can happen in one of 3 ways. The parties can certify the issue in the case, or the bankruptcy court can certify the case, or the intermediate appellate court can certify it. And, of course, the Circuit Court of Appeals has to take the appeal. Danielle, could you go over how a direct appeal by the litigants works, and when should counsel consider a direct appeal for a case?
So there are considerations, criteria for direct appeals that are set out in Section 158D2, and they're very similar to the criteria for taking an interlocutory appeal under Section 1292B outside the bankruptcy context, but a little looser. So it's appropriate to take direct appeal if the bankruptcy court's order involves a question of law as to which the Court of Appeals hasn't yet decided it, or it would require resolution of conflicting decisions, or it's just an extremely important issue, or an immediate appeal from the order would materially advance the progress of the case. Typically, that's true when you have, a legal issue that will dispose of either an adversary proceeding or a chunk of the bankruptcy case. And, as for how you do it, Judge Feeney, I think, as you just explained, in the bankruptcy court, the parties can stipulate to it. The bankruptcy court can do it on its own or by motion. The intermediate appellate court can do it by motion. So it's much easier to get that stage done than it is in typical litigation. But just as in 1292B, the Court of Appeals has to then take the case, and the Court of Appeals can take it or not take it for any reason or no reason. And Judge Graber can correct me if she thinks I'm wrong about that.
No, that's true. It is a matter of discretion to take a case that is certified, but in my experience, there's seldom a request or a certification. I'm not aware of any that has been turned down, but as I say, we seem not to get very many of them.
That's interesting.
I think there may be more of them after Bullard, which we'll talk about later, the Supreme Court's decision. One quick note about effective authority to enter a final order on appellate jurisdiction. There's a recent decision I'd like to bring the attendees' attention to that was issued after we did our materials, and it's from the 11th Circuit. In that case, the direct appeal was remanded back to the district court because the bankruptcy court did not have authority to enter a final order in a related to proceeding which was not the subject of consent. That's the decision of Wortley versus Sachs up on the screen now. Let's move to what orders can be appealed. The general rule under 158 is that only final orders can be appealed. In a bankruptcy case, there are often many disputes between different parties. Indeed, a bankruptcy judge literally can enter hundreds, even thousands of orders in a case. The Code and the Federal Rules of Bankruptcy Procedure do not provide a definition of what is a final order that can be appealed as of right, and the definition has been left to the courts in the case law. I'll simply note that the courts have developed a flexible approach to finality because of the nature of bankruptcy. Danielle, can you comment on the definition of final order?
Sure. So the best definition anyone has been able to come up with, Justice Breyer came up with a long time ago when he was still on the First Circuit, and I think it was reaffirmed by the Supreme Court in the Bullard case that we're going to discuss. A final order in bankruptcy is an order that finally resolves a discrete dispute within the larger case. Now, when you're talking about adversary proceedings, it's pretty easy because an adversary proceeding, of course, is just a mini lawsuit, and so the finality rules are the same as they would be in any litigation. An order granting summary judgment, et cetera, would be final. What's much harder is figuring out when there's a final order in a contested matter, and to do that, you have to define what the discrete dispute is, and that can be surprisingly difficult and contested.
Let's try to define it by way of examples. In the main bankruptcy case, can you give us some examples of clear final orders?
Sure. So an order granting confirmation of a plan, an order either allowing or disallowing a claim, a lien avoidance order, an order converting or dismissing the case, an order approving a sale, all of those have been held to be final orders because they finally resolve a discrete dispute within the bankruptcy.
In the main case, there are a few closer calls. Generally, denial of a motion for relief from stay is not considered a final order, but I can think of one circumstance where it would be, and that would be where the lift stay motion was denied on the ground that the security interest is invalid or unperfected, and that's the rule here in the First Circuit. So that would be a final order. And you mentioned in an adversary 12b6 motion to dismiss allowance or summary judgment as to all counts, those would be
Right.
final orders. Let's move to the definition of interlocutory orders as a study in contrast. The general rule is that an interlocutory order cannot be appealed as of right, with one narrow exception pertaining to Chapter 11 exclusivity orders under Code Section 1121. As in the case of final orders, there isn't any definition in the Bankruptcy Code or the Federal Rules of Bankruptcy Procedure of what is an interlocutory order, and that, again, has been left to the case law. Danielle, can you analyze the way we should determine whether something is an interlocutory order that's not appealable as of right?
Right. Well, it's essentially the obverse of something that's a final order. So, essentially, it's an order that doesn't finally resolve a discrete dispute, but that leaves some issues related to that dispute open to be decided. So, discovery orders, interim cash collateral and borrowing orders, and we just know now from the Supreme Court that denial of plan confirmation, at least in a Chapter 13 case, is not a final order. In adversary proceedings, orders that are interlocutory and can't be appealed include, the denial of a motion to dismiss, the denial of summary judgment, it's discovery orders, and that type of thing.
So if somebody wants to obtain leave to appeal an interlocutory order, how does that work? Danielle, can you provide some background?
Sure. So in order to do that, this is set out in the rules. In order to do that, you need to file a motion for the Intermediate Appellate Court to take up the appeal. It's filed in the Intermediate Appellate Court, and the justifications for interlocutory appeals are very similar to the justifications for skipping over the Intermediate Appellate Court and going straight to the Court of Appeals. If a party's rights are going to be finally determined in a way that can't be fixed, that is a potential basis for an interlocutory order. Or you can have, the same considerations as you do for a direct appeal, which essentially are, this is a controlling issue of law, it's going to materially advance the disposition of the case, but it's discretionary it's discretionary with the Intermediate Appellate Court whether to accept such a motion.
And the general theme of these three precepts, which serve as an exception to the general rule that an interlocutory appeal can't be permitted, is that it's an important question of law. Is that the gist of it?
I think it's for 158A3. I think it's that it's an important unresolved question of law, and that it will advance the case. That this is something that potentially is dispositive of whatever discrete dispute is at issue. Under the collateral order doctrine, you're more likely to see there something like the bankruptcy court has ordered a party to turn over privileged attorney-client communications. Once that's done, it can't be undone. And so even though a discovery order normally would not be final, that is the type of order that has sometimes been held to be final under the collateral order doctrine, because if you wait until after the dispute has been finally resolved, it will be too late to provide any remedy.
So the best
I'm sorry, and I believe the Forgate-Conrad doctrine is similar to the collateral order doctrine in that regard.
The best practice for a party who is aggrieved by an interlocutory order is to file a motion for leave to appeal, and that is addressed to the intermediate appellate court, not the bankruptcy court. And what's the best argument for a party requesting that?
Objecting to it? I'm sorry, for a party objecting to it?
Well, why don't you start with requesting it and then address objecting to it?
Sure. So, I mean, the reasons that you might get leave to have an interlocutory appeal would be, as I said, a controlling issue of law that would materially advance the disposition of the case, or, you know, some parties' rights are going to be significantly affected in a way that it can't be remedied after the case is over. In objecting to it, I think that, you know, you would want to emphasize that, you know, contrary to what the movement is saying, an interlocutory appeal will just slow things down. There's no, you know, there shouldn't be piecemeal appeals. It should all be done at once, and nobody's going to be harmed if proceedings continue. And this issue is decided at the end of the dispute.
One point I'd like to make, and I've noticed as a bankruptcy judge whose appeals are reviewed by both BAPS and U.S. District Courts as the Intermediate Appellate Court, is that the BAPS does quick and intensive screening of appeals to determine whether or not it is or is not an interlocutory order, and the BAP is more likely to issue some type of order to show cause why an interlocutory review should not be conducted, as opposed to U.S. District Courts, who frequently review interlocutory orders without that screening. Danielle, you mentioned Bullard. It is one of the more significant pronouncements of bankruptcy appellate jurisdiction, and the most recent done by the Supreme Court in May of 2015. It emanated from the First Circuit and my colleague down the hall, and I think it's essential to understand the effect of this decision on the scope of appellate jurisdiction. In this case, the Supreme Court determined that it and the Court of Appeals did not have appellate jurisdiction over an order denying confirmation of a Chapter 13 plan. Several courts now have applied this to a Chapter 11 plan, which has been the subject of disapproval of a plan. Danielle, what are the takeaways from Bullard, and are there any workarounds so that a party could get appellate review of confirmation?
Yes, there are. First of all, I should say I represented an amicus in the Bullard case. Although we were a creditor, we were actually arguing on the debtor's side that these orders should be final and immediately appealable, because frequently, especially in consumer cases, these issues will never get back to court, and they will never end up being resolved, and there will never be any certainty in the law, because in a consumer case, if a bankruptcy court says, no, this thing that you did in your plan is not lawful, and then, you know, says, go back and write another plan, and you get that plan confirmed, it's exceedingly unlikely, I think, that anyone is going to then take an appeal. And it's a little bit odd, but what the Supreme Court said is you can get around. What the Supreme Court said is, look, this is interlocutory because it doesn't resolve a discrete dispute. we were saying the discrete dispute is over this plan. The Supreme Court said no. The discrete dispute is over confirmation of a plan, and so that's not resolved until some plan is confirmed. And, you know, we pointed out that puts the debtor in a really awkward position, because it's what you then have to do is either move to have the case dismissed and then appeal the dismissal, which is one workaround, but a pretty awkward one, and one that would have some pretty unfortunate consequences potentially. Or you could go ahead, propose a different plan, get that confirmed, and then appeal from the confirmation of your plan. And, you know, interlocutory orders typically are folded into final orders, and you know, presumably you could get review that way. Both of those strike me as really odd, but those are ways to do it. Another way would be through the interlocutory review procedures that we've just been discussing.
I think that if you proposed a plan, though, haven't you waived any right to appeal?
Well, that doesn't seem to be what the Supreme Court thought. I think that, you know, the notion was that you could somehow get review of the plan that's been denied confirmation after a different plan has been confirmed. But I agree, it strikes me as very unintuitive.
And we already talked about lack of authority of a bankruptcy judge affecting finality, so we won't discuss that again. But before we talk about limitations on appellate jurisdiction, let's address the procedural issues that arise when a case is settled during the pendency on the appeal. What the general rule is that a bankruptcy court loses jurisdiction once an appeal is filed and sent to the intermediate appellate court. In 2014, the Federal Rules of Bankruptcy Procedure added a new rule called indicative rulings. And it used to be, before this rule, that parties notify the appellate court of their settlement, and then the appellate court would yield back its jurisdiction to the bankruptcy court for proceedings on a motion to compromise or to approve a settlement in connection with Rule 9019. Now the procedure is a little different, although I've seen it done both ways. With respect to the indicative rulings rule, the bankruptcy court now, without getting back its jurisdiction, can give an advisory opinion as to whether or not it would approve the settlement. So I think that procedure is somewhat helpful and can speed things up, especially if an appeal is under advisement or is in the district court. Let's talk about the three main limitations on appellate jurisdiction. An appellate court must determine its own jurisdiction, even if not raised by the parties. And there are three main reasons why an appellate court loses jurisdiction, and those are the three most frequent reasons for dismissal of an appeal. And they are that the appeal was filed late, that the appellant lacks standing, and finally that the issue before the court is moot. Let's talk about those three reasons for dismissing an appeal now. The general rule is that notice of appeal must be filed within 14 days after docketing of the bankruptcy court's order. However, like everything, there's an exception to that rule, and that is if a party moves to file an appeal late within 21 days after the 14, the intermediate appellate court can extend the time upon a showing of excusable neglect. I'm sorry, the bankruptcy court is the court to which that motion to extend time is addressed, not the intermediate appellate court. I stand corrected. But if you can't file a notice of appeal within 14 days, as a matter of practice, you really should file a motion to extend within the 14 days to avoid any discretionary dismissal. You don't have to you don't have to argue that failure was due to excusable neglect. So the time for filing the notice of appeal, absent an extension, is strict and it's jurisdictional. It's not waivable. However, a motion for reconsideration or a motion for new trial or a motion for relief from an order under Rule 59 or 60 does toll the time for filing a notice of appeal. There are a couple of different types of orders which cannot be the subject of a motion to extend time for filing an appeal. These are include a motion for relief from stay, sale orders, and orders confirming plans. Also, an appeal is premature if a motion for reconsideration is pending. So a party shouldn't file a notice of appeal before a decision on a Rule 59 or 60 motion. Those are the general rules on untimeliness, and there is more analysis in the written materials which you have. One of the other main reasons for dismissal of an appeal is lack of standing. In order to understand lack of standing in an appeal, it's important to contrast that with standing in a bankruptcy case. In a bankruptcy case, pretty much everybody has the right to be heard. The debtor, the U.S. trustee, the Chapter 7 trustee, a creditor. Contrast that with standing to appeal, and it's a much narrower universe of parties. In order to have an appeal to challenge, in order to have standing to challenge an order on appeal, a person must show that the person is aggrieved and that pecuniary rights are adversely and directly affected by the order that is the subject of a challenge. So, for example, in a Chapter 7 case, a debtor generally lacks standing to be heard in any appeal in the main bankruptcy case unless the estate is solvent. That is, it's a surplus estate and money's going back to the debtor. Also, a Chapter 7 debtor is generally unable to attack on appeal a sale by the trustee of the debtor's property unless the debtor's exemption or the debtor's discharge are affected. And likewise, an unsuccessful bidder in a 363 stay lacks standing to appeal. Again, there is an exception to that rule that has evolved, and that is where the challenge is based on flaws in the sale. For example, defective notice or failure to comply with a bidding procedures order. Next, there is a restriction on appellate jurisdiction for lack of standing if the order appealed from is a favorable order. Thus, a debtor cannot appeal an order confirming a plan that the debtor proposed, which is now somewhat called into question by the dicta in Bullard. And finally, the third main reason for obtaining dismissal of an appeal is mootness of the issue before the court. And like the other two reasons, lack of standing and untimeliness, this is a threshold issue which can be, should be addressed by the appellate court either on its own or at the request of a party. In summary, there are three types of mootness. statutory mootness for certain orders as provided in the Bankruptcy Code, constitutional mootness, and finally, equitable mootness. And we'll examine each one of these. There are two express provisions in the code setting forth statutory mootness for particular types of orders, and those are sale orders and borrowing orders. 363M provides that a reversal of a sale to a good faith purchaser cannot invalidate a sale unless the order of sale was stayed by the bankruptcy court. And the comparable provision in Section 364E is that the reversal of a borrowing approved by the court does not affect the validity of the debt or the lien given to secure it, again, unless a stay was granted. The thought behind these protections is that the buyers and the lenders will be less likely to come forward if an appeal can reverse an unstayed order approving a transaction. So, in a bankruptcy court, there are different ways that judges handle 363M protection. Many judges raise it themselves. Some wait for a party to raise it, and then some parties don't raise it but include it in a proposed order. The best practice is for the judge to address it at the hearing if the party doesn't, and either take an offer of proof or give parties an opportunity to present evidence on the good faith of the purchaser. I have found as a trial court judge that most parties present an offer of proof which is unrebutted, which can form the basis for the good faith finding, which is a finding of fact. There is an issue as to what is the scope of appellate review of a sale or borrowing order where the bankruptcy court has made the good faith finding, and there is a split of authority on the issue. In the First and the Second Circuit, only the issue of good faith is reviewed as opposed to the entire transaction. And appellate review is limited to whether the property was sold to a good faith purchaser or the loan was made in good faith. The old Cole decision from the First Circuit is included in the materials. In contrast, the Third Circuit Court of Appeals, Judge Ambrose, writing for the court, has interpreted Section 363M more broadly in the ICL Holding Company decision, 801 F. 3rd 547, a 2015 decision. In that case, Judge Ambrose expanded on the review, and although he said that the review couldn't invalidate the sale, he did say it's appropriate to inquire beyond good faith into the terms of the sale. Finally, a quick note on stays pending appeal with respect to a sale order, and also with respect to a relief from stay order. The bankruptcy rules do now, as of 2014, provide for an automatic stay of those orders to give parties who are aggrieved by those orders time to get to an intermediate appellate court to obtain a further stay. The second doctrine of mootness involves the United States Constitution. And it's a common law doctrine. Danielle, can you summarize the doctrine of constitutional mootness and then give us some examples of a case that would be moot?
Sure. So the requirement stems from Article 3 of the Constitution, which says that the judicial power of the United States can be used to decide cases and controversies. And the way that's been interpreted is that if there is not a live dispute between the parties, the court, as a jurisdictional matter, cannot hear the case. And what the court asks is, has the plaintiff been injured If so, was the injury traceable to the defendant's action? And finally, can the court provide a remedy? There are cases become moot all the time. So, for instance, if during the dispute the case settles, that's a sort of banal example of the case becoming moot. If something happens that renders the underlying question no longer significant to the plaintiff, then the case becomes moot. There are exceptions to mootness. For instance, if something is capable of repetition yet avoiding review, like challenges to elections, where once the election is over, a challenge to the procedures used in the election might be said to be moot. The court has said no, because that can happen again, and because it happens so quickly, it will avoid review if we don't review it now. So that's one exception to mootness.
That's a pretty narrow exception, though, because ordinarily it has to be the same plaintiff capable of repetition involving the same party.
It is narrow, yes.
Let's address the doctrine of equitable mootness, which is recognized in all of the circuits. Judge Ambrose refers to it as a tool in the equitable toolbox. I look at it as a form of abstention, where an appellate court will not hear an appeal, indeed will dismiss it, where relief is determined to be impracticable. Although every circuit does recognize the doctrine of equitable mootness, there is disagreement on whether it is proper. Significantly, the Supreme Court denied certiorari in the Tribune case on the propriety of equitable mootness, and there are decisions applying it and not applying it set forth in your materials. Most notably, even within the Third Circuit, Judge Ambrose and Judge Krause disagree on the applicability of the doctrine. We'll get to the arguments for and against in a minute. Danielle, in most cases, the argument of equitable mootness of an appeal is in the context of a confirmation of a Chapter 11 plan.
Correct. Some circuits have held that it only applies in that context. I believe the Third Circuit has done so.
What does an appellate court look at to determine whether an appeal should be dismissed for equitable mootness?
So the test varies in its articulation from circuit to circuit, and some circuits apply the doctrine of equitable mootness much more aggressively than others. But I think the slide gives you the basic concepts. The most important question is, has the plan been substantially consummated? Have most of the transactions under the plan taken place so that it would be really difficult to then unwind those transactions?
For example,
in the second circuit,
if unsecured creditors had been cut their checks and you couldn't get the money back, is that what you mean?
Yeah, I suppose that's one example. Or equity had passed into different hands. I mean, a plan. There can be all kinds of transactions under a plan that could potentially have to be unwound if confirmation of the plan were successfully appealed. So that's the most important question. Courts will also say, did the appellant try to get a stay? If the appellant obtains a stay, then there is no equitable mootness issue because the plan won't have been consummated. But courts will ask, did you try to get a stay? And then they ask, would unwinding these transactions hurt the rights of third parties who aren't before the court, or would it simply, scuttle the entire reorganization? And in those cases, courts will use the doctrine of equitable mootness. I'll just say I think it's been substantially overused, but there certainly are some situations where, as a practical matter, it may just not be possible to give the appellant the relief it's seeking.
Well, Judge Krause agrees with you, and the controversy about the doctrine is highlighted by the differences of opinion by Third Circuit Court of Appeals Judges Ambrose and Krause. I find their views interesting because they're both aimed at eliminating or deterring gamesmanship by either the plan proponent or the plan objector, and their views are noted in the slides, the slide that's up on the screen. Now, Danielle, can you summarize the arguments for and against equitable mootness and dismissing an appeal for equitable mootness?
Sure. So, on the pro-equitable mootness side, I think the biggest thing it has going for it is pragmatism. And, what Judge Ambrose focused on is we want to be able to protect reliance interests of parties who, for instance, have invested in the debtor, who have made investments in reliance on the finality of the plan. We simply can't have a world in which a bankruptcy can't really be resolved until every little appeal has been, taken care of. We do need finality in order for the business to emerge from the Chapter 11 shadow and go forward. Judge Ambrose also made the argument that Sections 363M and 364E, which we talked about before, about sale orders and dip orders, are evidence that Congress had an intent not to disturb consummated transactions. I actually think the opposite is true, and that those two provisions are evidence that if Congress had wanted to do the same thing for confirmation of plans, it would have said so. And I very rarely disagree with Judge Ambrose, but on that one point, I do. The arguments against equitable mootness, first of all, it's really a misnomer. I mean, it's not mootness. It has nothing to do with constitutional mootness, and in many cases, it's not equitable. It allows a debtor and the other plan proponents who are sophisticated to arrange things in such a way that even if a creditor has been unlawfully treated, the creditor will never be able to get review of that, and that's really problematic. And as Judge Krause noted, there is no statutory basis for it, and it has sort of crept into cases where it actually wouldn't be that difficult to provide some relief. So I think those are the concerns, and to an extent both are valid.
Let's assume that the appeal has proceeded beyond the dismissal stage. I had a couple of points before we get to brief writing and oral argument. I have made the reconsideration point before. The other point is that in an emergency situation for illness or incapacity or another emergency reason, the intermediate appellate court can expedite a decision on an appeal, but a party needs to ask for it. And finally, parties can be sanctioned for proceeding with frivolous appeals. A party can move for damages for a frivolous appeal, or the court can sua sponte raise the issue. Anybody who's the target of such a sanction motion or order to show cause has to be given due process. Let's spend a minute on motions for stay pending appeal. An aggrieved party has 2 bites of the apple to obtain a stay pending appeal. It must proceed in the bankruptcy court in the first instance, but if it's unsuccessful there, it can then go to the intermediate appellate court. It's an injunction standard. There are 4 factors that both the bankruptcy court and the intermediate appellate court will consider, as outlined on the screen right now, and also in more depth in your material. Let's spend some time with Judge Graber on proceeding with the appeal. Judge, can you describe the Court of Appeals process for, in general, for bankruptcy appeals?
Yes, I would note, of course, that every circuit has its own way of doing things, but in the Ninth Circuit, the way a bankruptcy case is processed, there are essentially 3 main steps to it. First, central staff will inventory every civil and also criminal appeal, as it turns out. And by that I mean they will examine the case to determine initially whether we have jurisdiction, and if not, or if it's believed that we don't, it's off on a different track. Secondly, they summarize a statement of the issues, and third, they will identify potentially related cases so that they can be assigned to the same panel. The second phase is random assignment to a 3-judge panel. Some go into what we call oral screening, and those receive no oral argument unless one of the 3 judges thinks that the case is too complicated for that. Or it goes to a regular merits panel. Typically, a bankruptcy case is not likely to go to an oral screening panel unless someone is appearing pro se or unless there is an issue of law that has recently been decided definitively and there are simply some follow-on cases. The third major segment is the decision itself. Almost all of our cases are probably 80%. Although I haven't looked at the statistic recently, are decided by non-precedential memorandum disposition and the remainder by a precedential opinion. So that's kind of basically the flow of our caseload, and something that's important for practitioners to remember is just the vast number of items that we deal with. This will inform some of my brief writing tips later. We process something like 12,000 appeals per year.
If a party wants to make sure that an issue is not waived on appeal, what's the best way to preserve an issue other than making sure it's in the notice of appeal?
Well, it has to be something that was presented initially to the bankruptcy court and to whatever intermediate, if any, whether it's the district court or the BAP. So something that you think of just after everything's over and right before you come to the Court of Appeals will be deemed waived. So it needs to be presented to the court initially with the idea in mind that if it wasn't presented, then the bankruptcy court couldn't have made a mistake and there's nothing for us to fix on appeal.
Judge Graber, in preparing for our webinar, you emphasized the importance of knowing the standard of review, and there are several. Danielle, could you briefly comment about the various standards of review that an appellate court uses in viewing the record, both in and the importance of those standards in selecting issues for review and arguing for affirmance or reversal?
Sure. So this is absolutely critical. If you are an appellant, you want to, let's just go through them first. So the standard of review for findings of fact by the bankruptcy court is clearly erroneous, which has been described in colorful language as a decision must strike us as more than just maybe or probably wrong. It must strike us as wrong with the force of a 5-week-old unrefrigerated dead fish. So it's quite difficult to get factual findings overturned under the clear error standard of review. By contrast, on legal conclusions, the appellate court owes the bankruptcy court no deference whatsoever. It's reviewed de novo. And for certain types of rulings that go to sort of management of the case, sanctions, that type of thing, they're reviewed for abuse of discretion. I'm skipping over mixed question of law and fact because I think those questions usually can be parsed into a fact part and a law part, to which clear error and de novo respectively apply. So if you're the appellant, you have to have an issue of law. If you don't have one, you can't make one up. But if you can present the bankruptcy court's error as an error of law rather than an error of fact, that's what you need to do. And you need to start thinking about that in the bankruptcy court, in the way you present the issue to the bankruptcy court. And vice versa for the appellee. You want to portray what the bankruptcy court did as findings of fact as to which the court should get deference because the court, is closest to the case and it was within the court's discretion. So appeals frequently turn on this.
And finally, there are certain types of rulings that are discretionary rulings by a bankruptcy judge, extensions of time, continuances. These are reviewed for abuse of discretion. And do you agree that those are rarely reversed on appeal?
Absolutely. I mean, it's sort of similar to mixed questions. Unless you can find it within the abuse of discretion, an error, for instance, in articulating the legal standard that applies, it's very unlikely that you're going to get something reversed on under an abuse of discretion standard. If you can find a legal error that's reviewed de novo, that is typically what you need to get a reversal.
Well, let's proceed with what is the most important document in an appeal, and that's the brief of both parties. Judge Graber, can you outline for us the best practices for brief writing?
I'd be happy to. And I want to emphasize what you've just said, Judge Feeney, which is that the brief is much more important than oral argument. And in part that's because many cases are not argued orally, even if they were assigned initially to a merits panel. We often submit cases on the briefs if all three judges agree that oral argument would not be helpful. And also, as mentioned earlier, waiver or forfeiture is always a question. So even if something was raised distinctly at the earlier phases of the litigation, something that is not argued distinctly in the brief is also considered waived. The reason why the standard of review matters so much is that you have to view it as it's the lens through which you select your issues as well as through which you write the persuasive argument. It is much better to select only a small number of issues, maybe 2 or 3, select the strongest ones, and the standard of review will help to determine whether they're strong because, as has been mentioned, if the standard is clearly erroneous or the standard is abuse of discretion, it's quite hard to overturn what happened below. I'm a great believer in simplicity. We read an enormous amount, as I mentioned earlier. We process so much paper or so many digital files that it's helpful if you use short words, write in short sentences, divide things into short paragraphs, give us headings so that we know where you're going. And in fact, many judges read the table of contents first, and if it simply says jurisdictional statement, argument, conclusion, it's not very informative. Active verbs keep us awake. It's important to follow the rules of grammar and usage, and I know that sounds picky, but if you're sloppy in your use of spell check, or if your grammar is poor, or you don't follow the rules that are set out in the Federal Rules of Appellate Procedure, then it causes us to view your entire brief with skepticism. I don't know if all my colleagues would agree with this, but I prefer that people avoid footnotes whenever possible. They can be useful occasionally. For example, if you were to say, there are 40 cases on this topic and the majority rule is X, I don't need a string cite, but a footnote might be helpful. But ordinarily, let us read double-spaced material. Also, it's helpful to avoid repeating, to prune out things that are not necessary. For example, we will often see a statement of facts that contains date after date after date, and I expect to see an argument that something wasn't timely, but in fact it's just there because it's there. So if something isn't important, leave it out. If you have one case on point, talk about it, don't give us a string cite. If you're representing the appellee, I'm often asked the question whether you should respond to the argument in the same order that the appellant laid it out. And I would say it's up to you, but usually it's helpful because you don't want to leave out an issue by mistake, and oftentimes we'll lay the briefs side by side and look at the argument on one issue and then the other argument on that same issue. So it's helpful if there's a matchup unless it's not particularly logical. In your statement of facts, please always cite the record for any statement. Please organize the facts into a narrative so they tell us a story. I'm also a great fan of appendices or illustrations. So if you have a long item that we need to read, such as excerpts of a contract, put it into an appendix. One of the hardest things for lawyers to do is to deal honestly with unfavorable facts and unfavorable cases, but it will help you in the long run if you don't exaggerate your position and you thoughtfully confront the problems of your case, because it helps your credibility and therefore the credibility of your client. I recommend fierce editing. If you are in a situation in which you practice with other lawyers and you're able to do this, have a peer look at a draft of your brief and make suggestions. But if you are in a small firm or you don't have the resources, your client can't pay for that extra time, put your brief aside and come back to it a week or 2 weeks later, and you yourself will have a different perspective and can do some editing.
Judge Graber, does the Court of Appeals like amicus briefs, and when are they useful from the court's perspective?
We like them when there is an issue of law that is important, and when they add something to the conversation. It isn't helpful to necessarily to line up a lot of amicus briefs. If there are 40 of them, it's less likely that we'll actually read each one carefully because they're just a vast number. And simply weighing in and saying, here are 20 on one side and 20 on the other, it's interesting to know that, but it's not especially helpful. It also is not helpful if it's not primarily an issue of law that we're dealing with, because then it's a matter of reading the record and understanding the context for a discretionary call by the court. So if you have an issue of law, particularly one that's new, important, undecided, yes, we relish the opportunity to hear from knowledgeable people, especially in an area like bankruptcy, in which almost none of us is an expert, or in fact far from it. So they can be very, very helpful, and if they are reasonably even-handed in their tone, it's helpful also, because simply being passionate isn't necessarily persuasive.
Let's proceed with the best practices for oral argument. What is the best way for counsel to prepare, and what does the court want to hear?
The best way to prepare is to go over everything again before you get to court, because we do expect people to know both the record and the relevant cases backwards and forwards. So updating the legal research at the last minute is extremely important. Expect counsel to submit a 28J letter, is what it's called, giving us updated citations for new cases. Please don't surprise us at oral argument and stand there and give us the citations that you haven't given in that form. If something just came out that morning, submit a little slip of paper to the clerk of court right before the argument, and they'll circulate that to us. If you have the time and the opportunity to watch the panel in action a previous day, for example, that's helpful, but is often not available. What do we want to hear? Well, we want to hear that you're prepared, because we're likely to ask you questions about the record in particular. We want to hear the main issues, start in them right away. We've read the briefs and the record. We're not a jury, and we know there are real people behind the case, but pointing out that your client is in court and that they have a particular equity on their side is not necessarily helping us get to the main argument. It's helpful if you focus immediately on what it is you hope to cover, 2 or 3 points, because if you give us a short introduction, I hope to cover A, B, and C, at least we know what your main points are, because once we start asking questions, you may never have the opportunity to cover all of those, but at least we know what you consider to be the most important. It's helpful if you have a coherent legal theory of the case. And if there is a legal issue involved, please be able to describe in relatively concise form the rule that you would like us to adopt, because we're looking not only at your case, but at future cases. And we want to have an understanding of the implications of the rule for which you are arguing for other cases. So if you can put on our hat as you're preparing and think about the necessity for us to have a rule that is good for other cases as well, that's very helpful. Another thing that is important is to be able to say exactly what relief you're seeking. It's quite surprising how often counsel are not able to say what they would like the tagline to be exactly. So be prepared to explain precisely what your client wants and why they should receive that relief. We really like it when counsel answer the questions asked, even if they're dumb questions, and particularly if they'll answer them at the time they're asked. It's not helpful to be evasive. My rule is I'll ask the question 3 times, and if it doesn't get answered, I simply figure I'm never going to get an answer, either because the lawyer doesn't want to or the lawyer can't, and so I'll move on. But the question is still there for me to answer for myself. It's helpful to be yourself. You can learn from watching other lawyers, but fundamentally you simply have to be you, and you're engaged at the highest level. A good oral argument is a conversation, and make eye contact, have a conversation with us about these interesting legal issues. Finally, for the appellee, listen to what the questions are for the appellant when they are in the hot seat. And it's often helpful to start by answering in your argument the questions that were asked of your opponent. And what do we not want to hear? We don't want to hear you read long quotations or read your remarks. We don't want you to whisper or race through your remarks. So if you can speak sufficiently loudly and slowly, that's helpful. As I mentioned, we don't appreciate evasion. We prefer not to be interrupted, although sometimes we do it to you and to each other. We particularly don't like sarcasm or denigration of opposing counsel or the court being reviewed or the applicable precedents. And finally, I would mention something that we do see fairly often, but most of us don't appreciate, and that is mentioning particular judges by name. For example, it's not helpful to have someone say, well, the closest case on point is Jones versus Smith, which, Your Honor, Judge X, you wrote, and we love this opinion. It's really quite unnerving and not helpful, because the precedent is whatever it is, whoever drafted it and whoever was on the panel. So that's, I guess that's a summary of the main do's and don'ts.
Judge, is there any particular way that Circuit Court of Appeals judges handle bankruptcy appeals as contrasted to other types of appeals?
There are a few things that are worth knowing about what's special or different about bankruptcy appeals and the approach, at least in my experience. And obviously this will differ from circuit to circuit and from judge to judge. It seems to me that we are slightly more apt to submit a case on the briefs without oral argument because the answer will sometimes depend on a factual review of the record, and that doesn't necessarily make a good subject for oral argument. If there is a legal issue involved that's undecided, we are likely to have oral argument, but keep that in mind when you're writing the brief as to encourage us to hold oral argument. The second thing to know is that the vast majority of circuit judges have very little familiarity with bankruptcy law. And even more than in other cases, it's important to write and speak in plain English without jargon whenever you can. And to consider using visual aids such as charts when you're writing the brief or illustrating a pointed oral argument. A piece of that is that the questions we ask may seem quite rudimentary or uninformed. So if you can avoid the eye roll when you're answering them, that's very helpful, because we may have to ask sort of step-by-step, somewhat ignorant questions in this area. And I want to make one final point, which alludes to something that both of you said earlier, which is what happens when there is a decision of the BAP. We have a very active BAP in the Ninth Circuit, and it's my experience, which goes with the statistics that you gave earlier, that judges are very likely to respect the expertise of the BAP. So if you are taking an appeal from a BAP decision as distinct from a district court decision, you should be even more prepared than normal if you are representing the appellant, and be prepared to explain where the bat went wrong.
Let's spend a few minutes on Supreme Court practice. Danielle, you have substantial...
Sure. So I'll try to go through...
What's the best way to get a petition for cert considered?
Sure. Thanks, Judge Feeney. So I'll try to go through this relatively quickly, given the time. So the slide that's up right now essentially tells you the mechanics of how you get there. A cert petition is due 90 days after the judgment of the lower court issues, although that's extended by a petition for rehearing. That, like other filing deadlines, this is jurisdictional. The court grants only a few petitions. So, I think there are quite several thousand, 7,000 or 8,000 a year, and recently maybe 70 have been granted. Now, a lot of those are prisoner petitions and that type of thing that may not have much merit, but it's very difficult to get a case to the Supreme Court. So, on the next slide, arguments for granting cert are laid out. Supreme Court Rule 10 tells you what the court standard is. It says that the court will grant cert when a court of appeals has split from another court of appeals or has decided an important question of law that should be settled by the court or in conflict with the decision of the court. And it specifically says certiorari is rarely granted when the asserted error consists of erroneous factual findings or the misapplication of a properly stated rule of law. And that's where most cert petitions fall down. So, and the ideal cert petition, and this depends on your case. I mean, you have to have the right case. But the ideal cert petition from the Supreme Court's view is going to involve a pure question of law that can be stated relatively simply, where courts of appeals have divided on the answer. Say 3 courts of appeals have decided one way, 3 the other. The issue, does not need to be of broad importance, but it helps. And the case has to be clean. There can't be any potential problems with jurisdiction, with standing, mootness. They don't like cases where there was an alternative basis for the decision below, because that means their decision might not actually govern what happens, or cases with messy facts, or cases that are in an interlocutory posture. All of those things are things that they do not like. So when I clerked for the Supreme Court, one of the things we had to do was read all the cert petitions that came in, and we divided them up, and we would write a little memo for each one. And this is the kind of thing the memos would say on most cert petitions. We would say it's splitless. In other words, there is no split, or the circuit split that the petitioners claim is there is not really a split, because if you really look, you can reconcile the cases with one another. We'll say it's fact-bound, which means that the issue here is whether the lower court erred in its application of law to fact rather than in its understanding of the law itself. Relevantly seeks error correction. We don't want to just fix, the court doesn't want to just fix mistakes that lower courts made, even if they were really bad mistakes, unless they can announce a generally applicable principle of law in doing so. Sometimes we'll say it needs percolation. It would be better to have more fully developed opinions by the courts of appeals so that we can be sure the issue has been fully aired before it comes to the court. Or, as I was saying before, a lot of cases have vehicle problems, just, some aspect of it that might make it more difficult for the court to reach and resolve the clean legal question. So the next couple of slides are about briefs on the merits. So this is what happens after cert is granted. It's similar to the points Judge Graber made, all of which I very much agree with, but there are some differences. So unlike in the Court of Appeals, in the Supreme Court, you want to focus your argument on the legal question that was your question presented. You don't want to focus on the record unless that's somehow necessary to an understanding of the legal question. The court rarely takes the step of applying a legal principle to the facts of the case. Typically, if it finds the lower court applied the wrong standard, it will remand the lower court for the lower court to do that in the first instance. The Supreme Court doesn't get its hands dirty with facts if it can avoid it.
Are there any better arguments for getting a cert petition granted in a bankruptcy case?
No, I think bankruptcy cases are essentially the same as the typical case. Almost all the bankruptcy cases I've seen granted in recent years, there was a clear, acknowledged circuit split where one court of appeals had said, I disagree, or we disagree with this other court of appeals decision. And sometimes they can be really minor technical issues. Sometimes they can be pretty important issues. But that is primarily what the court is looking for in bankruptcy cases.
Could you spend a few minutes on best practices for oral argument before the Supreme Court? I know that you recently argued the Jevick case before the Supreme Court.
Yes, sure. So, I mean, as with the Court of Appeals, this is a generalist court. They do not know anything about bankruptcy. You need to talk to them as generalist judges, and you need to connect bankruptcy principles up with common sense and, with what they understand. You, as Judge Graber said, you don't want to use bankruptcy jargon. If you are a bankruptcy practitioner, though, it is helpful, for the court to know that, because they will ask you, how do things work in bankruptcy court? And you need to be ready to explain the world of bankruptcy to them. The Supreme Court loves asking hypotheticals, and I've seen this happen so many times, even with terrific advocates. The first thing you will want to say and will say is, that's not my case. That's not helpful. They know that. So you really need to try to address their hypotheticals on their own terms. And this is really critical. When you're up there, you're having a conversation with the justices. So you will have your two or three main points that you want to get out during your 30 minutes. But what's really important is to find the weak points, the concerns that the justices have, and address them. So the questions are your friend. Questions are an opportunity to persuade a justice. And, that's really the best way to think about it. And then finally, I think Judge Graber may have made this point about the Court of Appeals oral argument as well. If you're going second, or if you're doing rebuttal, don't just start with something you had prepared before. Listen carefully to what the justices asked the person before you and pick up on those themes. Start with where they are, what they're concerned about.
Well, that's
that is it.
Our slides. Are there any questions that members of the audience had that they'd like us to address?
There was one earlier that I can briefly address that asked whether there was question about the constitutionality of the BAP. And we did have a case in the Ninth Circuit, Ozene, O-Z-E-N-N-E, in which a three-judge panel, the majority, held that the BAP was not a court over a dissent. The case was taken in bank and decided on different grounds, so that those opinions are vacated. So, to my knowledge, there isn't a case out there on this question other than the one that's been vacated, but it is a question that may arise again.
Yeah, it's hard for me to see. I apologize.
Go ahead.
I was just going to say it's hard for me to see how Stern could make BAPs, unconstitutional in their totality. What it does mean is that nobody can be forced to go to a BAP. That's already the practice, though. Any party who wants to go to a district court can. And there is always the opportunity for Article 3 review in the Court of Appeals, but there are some things that the BAP won't be able to do. I mean, they won't be able to enter final judgment on a non-core matter. So that is something to think about when you're choosing between them.
I think it boils down to consent, as Danielle pointed out, especially in light of the Supreme Court's decision in Wellness. If parties consent to going to the BAP, I think it works. If they don't, then one of them needs to elect to go to the district court. Were there any other questions?
I think there was one other question, which was, how often does the Court of Appeals agree to take a case on direct appeal? Is it worth doing? I think it is worth doing in cases where time is of the essence, which it often is if you're appealing plan confirmation, for instance. I don't actually know how often it happens that the Court of Appeal agreed to take a case. I would hope that they're making use of that tool because, given the time-sensitive nature of bankruptcy appeals, having to go through this two-step process, I mean, it's unclear why it would be done for any appeal, but, there are definitely going to be occasions where there's an important legal question. It's not going to get resolved unless the Court of Appeals agrees to hear it right away. So I hope more used in the future.
There was one other question that asked the source of the quotation about the dead fish.
I have that. I can go back to the slide, and the person can take the citation down. It is, to be clearly erroneous, a decision must strike us as more than just maybe or probably wrong. It must strike us as wrong with the force of a 5-week-old unrefrigerated dead fish. Parts and Electric Motors, Inc. versus Sterling Electric, Inc., 866 F. 2nd, 228, at 233, 7th Circuit, 1988. Kudos to the 7th Circuit. And I also think it may be in the materials as well. Well, if there are no further questions, thank you for staying over the allotted time, and we appreciate the attendance of all of the audience, and thank you to Judge Graber and Danielle for their excellent advice and pointers. Amy Quackenboss, I'll now send it back to you.
Thanks so much, Judge Feeney, and thank you also to you and Judge Graber and Danielle for really sharing your expertise on bankruptcy appeals today. Just a reminder for those who have purchased CLE, you'll receive a follow-up email from us with instructions on how to obtain your credit. I encourage everyone online to register for tomorrow's Eye on Bankruptcy program, which is ABI's free monthly online video show analyzing the latest judicial decisions. You can register at eyeonbankruptcy.com. And also, we hope that you will join us for our next ABI-Live webinar on March 9th, which will focus on the roles of secured, undersecured, and unsecured creditors and committees in asset sales. You can register for that on ABI's website at abi.org. Thanks again to our panelists, and thanks to all our attendees. Hope everyone has a great day.
Thank you all.
Thank you.
Thank you.